In this edition, more devastating changes to the 485 visa rules which took effect yesterday. Skill assessment bodies can now lose their accreditation, domestic violence provisions extended to more visas, more details on the National Innovation Visa, and a new labour agreement for religious workers and ministers. Hi, I'm Karl Konrad, and you know the Immigration Department deliberately releases bad news late Friday afternoons, hoping the general media will miss it while they are all down the pub for the end of week drinks. But don't worry, we are always here on the ball to make sure you know what's happening in the world of Australian migration. So I'm afraid first up, the news is not so good. Just when we thought we could trust the government would not make any more changes to devastate international students, they proved once again they are prepared to stoop to the lowest levels of integrity by making changes that may cause many students studying here suffer tens of thousands of dollars wasted. Yesterday afternoon, the law changed for the 485 visa. The new regulations ensure those who have studied graduate certificates and in certain cases graduate diplomas will not be able to use these qualifications to access the 485 visa. Firstly, the changes for graduate certificates. It was only on the 28th of June this year that Claire O'Neill announced that graduate certificates were to be included to meet the definition of degree for the purpose of the Australian Study Requirement, the ASR. However, the government has removed the link to use the ASR in the 485 visa legislation and instead created its own definition of degrees, which does not include graduate certificates.
Control, Alt, Delete.
Therefore, the time and money spent studying these courses cannot be used to meet the 485 visa new requirements. Many master's degrees have graduate certificates as a prerequisite 6-month course. They are generally a 2 years package program, and hence for over a decade they have been accepted to meet the definition of the ASR, and indeed it still will be. In relation to graduate diplomas, they are still accepted in the new 485 definition of degrees, but now, in the regulations, they can only be used if they meet the following 2 criteria. Firstly, the graduate diplomas must have been started after the completion of a bachelor, master's or PhD program in the same academic year or the next one. And 2, the course content must also be relevant to one of those degrees. In the case of a graduate diploma, the course leading to the qualification is a related course of study to the course leading to the award of the preceding degree for the graduate diploma, and is commenced within the same or the next academic year as the academic year in which the preceding degree for the graduate diploma was completed. Not satisfied with devastating the education sectors by driving vocational colleges to bankruptcy with their failed student cap legislation, this government is again turning towards limiting of hundreds, if not thousands, of international students from accessing the 485 visa. It is the very same MO of how they devastated the lives of thousands of international students who had turned 36 from accessing the 485 graduate visa. The government has decided that the authorised skill assessment bodies who conduct migration assessments for the various visas must now work under government oversight and be subject to penalties which may include losing the ability to conduct such skill assessments. In Australia, being a skill assessment authority is a big money spinner, and for the last 2 decades they have been given the authority to conduct such assessments largely unregulated and unsupervised. And now that is all about to change. The Migration Amendment Skill Assessing Authorities Regulation 2024 is about to shake up the system to give the Skill Assessment Minister the power regarding assessing authorities that deliver these skill assessments. The Skill Assessment Minister is in fact the Minister for Skills and Training, Andrew Giles, our former Immigration Minister. In the recent migration strategy outcomes, the performance of many skill assessment authorities was highlighted as a hindrance to getting skilled workers a residence visa as soon as possible. I can hear all those Trade Recognition Australia and VitaSess applicants typing their comments agreeing that these two authorised bodies need to improve their processing times as soon as possible. In the explanatory statement of these new laws, it said, historically, quality assurance of the assessing authority sector was managed on the basis of goodwill between the assessing authorities and the government. However, public consultations have indicated quality outcomes in relation to the performance of assessing authorities cannot be sufficiently ensured through voluntary compliance alone. The Skills and Training Minister now can legally revoke the approval of an assessing authority in certain circumstances. This is a very big change indeed, and it will be interesting to see how Andrew Giles will get the Department of Employment and Workplace Relations, which is in charge of the TRA, to ensure that the TRA gets its act together and assess those trade applications ASAP. We are all very sick of seeing this excuse on the TRA's website, and the last one being posted on the 9th of December, where it says, as usual, the Job Ready program is experiencing a high number of applications and average processing times are currently longer than expected. So, Minister Andrew Giles, it's time to get that stick out and show that you've been given the power. There has been an update with a new Migration Amendment, Family Violence Provisions and Other Measures, Regulations 2024, to add to the following new visas. The parent visas, subclass 103, 143, 804 and 864, remaining relative visas 115 and 835, carer visas 116 and 836, business talent 132, Pacific engagement 192, and the business innovation and investment visa subclass 888. As we discussed in a previous news edition for other visa subclasses, these provisions allow case officers to assess what domestic violence has occurred and whether the victims of this violence can still have their visas granted even if the main applicant is refused their visa, being the perpetrator of the domestic violence. These provisions also intend to ensure that a victim survivor can leave a violent relationship without adverse impacts on their pathway to permanent residency visas. Of course, all of this is very complicated, so if you need assistance in these circumstances, please book an appointment to discuss it with us. More details have been released regarding the National Innovation Visa, the NIV. Here's just a recap on who the department is seeking. Global researchers, entrepreneurs, innovative investors, athletes and creatives who can make significant contributions that will benefit Australia's future prosperity. With the new NIV, you must submit an expression of interest using the IMI account like many of the point skilled visas. Unlike the point skilled visas though, the EOIs of the NIV cannot be updated once it's been submitted. So once it's in, it's all set. If you want to change it, you will need to withdraw it and create a new one. Under the old global talent system, many people wanted to keep updating their information with either new work experience or research. This was a real hassle for the government, so now the information cannot be updated once it's in the system. The information will remain on the department's computers for up to 2 years, and you will just have to wait and see if you get that invitation. The government has a priority ranking of who to choose from in the new EOI pool of talented people by creating a new Ministerial Direction 112. This direction aims for, firstly, recipients of internationally prestigious awards. This includes Nobel Prize laureates, Field Medal recipients, Booker Prize winners, or Olympic gold medalists. Number 2, exceptionally talented people in their field who are endorsed by a relevant Australian state, territory or federal government agency, such as the CSIRO. Gone are the days with the global talent process where you could get nominated by your boss, a skill assessment body or individuals. Number 3, people with exceptional skills in critical technologies, renewables and low emission technologies and health industries. Number 4, exceptionally talented people in agri-food and ag-tech resources, defense capabilities and space, education, financial services and fintech, and infrastructure and transport. Now, the Immigration Department has a whole list of who they consider to be exceptionally talented individuals, which you can check out later using the link in the description of this video. Effective from yesterday, the updated Minister of Religion Labour Agreement introduces significant enhancement to skilled migration pathways for religious organisations in Australia. The key updates are: religious workers now have improved access to permanent residency, facilitating long-term opportunities to contribute to Australian communities. Revised criteria being the adjustment to salary thresholds, qualifications, work experience and English language requirements to ensure the framework accommodates diverse religious practices and organisational needs. And it's designed to give broader access. The agreement supports religious organisations involved in education, charitable work and the promotion of their beliefs by enabling better access to skilled overseas workers. You can check out more details of these changes on the department's website, and as usual the link will be in the description of this video. Well, that's the end of another busy week. Next week we will be covering more issues in relation to the new CSOL, the 482 visa and the 186 PR visa. In addition, we will be highlighting some of your comments in relation to these changes to assist in ironing out some confusions. As always, take care out there and I'll see you next time. So bye for now.